Hi, I'm Jason Carnell, and thank you for visiting my website. I'd like to talk to you all about the conditional discharge statute in the state of Georgia today. You see, conditional discharge, the statute is O.C.G.A. 16-13-2, is a first offender type program specifically for drug offenses. Like first offender, you can only use this conditional discharge once in your lifetime. Now, the benefit of a guilty plea under conditional discharge is that once you complete the terms and conditions of your probation, the charge against you is effectively dismissed. The first thing you need to know about conditional discharge is that it does not alter your sentence. If your plea agreement includes a 2-year sentence of probation, conditional discharge does not change that. You still do 2 years of probation. If your plea agreement includes a $1,000 fine, you still have to pay the fine. Conditional discharge doesn't alter that. What conditional discharge does is it allows you to state honestly that you have never been convicted of a drug offense, because at the conclusion of your probation, the judge effectively reopens your case and discharges it. So despite your plea of guilt, or your conviction for that matter, you can state honestly that by law you have not been convicted, so long as you complete the terms and conditions of your probation. Now, most drug offenses carry with them several administrative consequences, like the loss of driving privileges or the loss of eligibility for federal student aid. When you plead guilty under conditional discharge, you will endure none of those consequences. There are disadvantages to this statute. For example, you will be on probation. This means you will have to pay the monthly probationary fee until your probation ends. Because you were convicted of a drug offense, your probation officer will very likely have you submit to random drug screens. Often these probation officers are moody people who generally do not like those under their supervision. And they won't lose any sleep over revoking your probation and sending you to jail should you commit a violation. Finally, should you commit any violation of the terms of your probation, the judge can revoke your conditional discharge and adjudicate you guilty. This means you will be saddled with an actual conviction for a drug offense on your record and all the administrative consequences that come with it. Another disadvantage of conditional discharge is how it appears on your Georgia Crime Information Center criminal history report. The arrest and the original charge will remain on your criminal history. Underneath that arrest and original charge, it will read, quote, 16-13-2 conditional discharge, end quote. It will not actually say that you were convicted, but anyone who knows how to read a GCIC criminal history will know exactly what that means. Fortunately, new Georgia law allows you to apply for records restriction down the road to limit access to this information. At the end of the day, conditional discharge is usually the best option available for first-time drug offenders in counties and municipalities that do not have a pretrial intervention or diversion program. While conditional discharge does not offer all the same benefits of PTI, it is a way to shield yourself from some of the consequences of a drug conviction in Georgia. If you or someone you know has been charged with any drug offense in the state of Georgia, please visit my website at www.carnellfirm.com. I can be reached with your questions via email at jason@carnellfirm.com or by phone at 770-322-4990. Thank you for watching my video, and I look forward to hearing from you.